Hello and welcome. My name's Kirsten Whitfield and I'm a Director in Fieldfisher's Privacy, Security and Information Law team. I'm joined by Pilar Arzuaga, who's a Senior Associate in our team, and Pilar and I will take you through data protection impact assessments, how to create them, when to use them, and when to review them. This session is part of our Get Data Protection Fit series. We're now on to Module 2B, where we put data protection into practice. And this is the second segment of Module 2B, where we talk about DPIAs. By the end of this session, you should have a better understanding of the types of processing that would require a DPIA. You'll be able to create your own DPIA process and carry out your DPIAs. Pilar and I will be taking a look at what a data protection impact assessment actually is, why you would carry out a DPIA, when to use one, how to create one, and when to review it. So what is a data protection impact assessment? Well, it's a process that you document, and that process is all about helping you identify and minimize data protection risks of any project or personal data processing. And the focus here is the risk to data subjects. Now, if a data protection impact assessment is done properly, it will help you assess your data protection compliance. So how are you going to go about complying with the general data protection regulation in Europe and also local data protection laws that you might need to comply with? And by documenting it in the DPIA, you're also demonstrating how you're going to comply with those laws. Now, bear in mind that a data protection impact assessment may be given to a data protection regulator if they ask for it. So this is a very powerful tool for accountability and demonstrating your compliance. One key thing to bear in mind when carrying out your DPIA is that it's not the case that you are required always to make sure that you've eradicated every last speck of risk to data subjects, but you should be looking at how you can minimize that risk. You're looking at, is it an acceptable level of risk given what you're trying to achieve with the personal data processing? So actually part of the DPIA process is also looking at alternatives. So how else could we achieve this same purpose but with less risk? And why would you carry out a DPIA? Well, the obvious answer is it's mandatory under the GDPR in certain circumstances, so that's a fairly good reason to carry out a DPIA. So the GDPR says that if there's any processing of personal data that's likely to result in high risk to the rights and freedoms of data subjects, that's when you need to carry out your DPIA. That's in Article 35 of the GDPR. And then there's the non-compliance risk that you face if you didn't carry out a DPIA when you were supposed to. So the GDPR says that if you don't carry out a DPIA that you were supposed to, you could be open to enforcement action, and that could include fines of up to 10 million euros or 2% of global annual turnover, whichever is the higher. But actually, aside from the enforcement risk, there's lots of good reasons to carry out a DPIA. It's a very good way of going through in a very structured way and looking at how you're going to comply with your data protection obligations as an organisation. And actually, DPIAs are not a new thing. They've been around in some shape or form for those sorts of reasons for some while. So before the GDPR came into force, they may well have been referred to as privacy impact assessments. So, and actually, even if you don't need to do a DPIA, having a documented review of how you're going to comply with data protection, it's really helpful to make sure that things don't fall through the gaps, and it's great for making sure that you're complying with your accountability obligations as well under the GDPR. So you're demonstrating your compliance with the GDPR more generally. And these reviews of your data protection compliance, they don't always have to be data protection impact assessments in the official sense. They could just be what you would call a privacy review or something else.
Thank you, Kirsten. So, we said that any processing involving high risk to the rights and freedoms of individuals should be assessed through a data protection impact assessment. Let's see when to use a DPIA. Under the GDPR, we can see a number of instances in which a data protection impact assessment is required. For example, processing involving profiling or automated decision making, which will have a significant effect on data subjects, large-scale processing of special categories of personal data, processing of personal data relating to criminal convictions and offenses, or systematic monitoring of publicly accessible areas on a large scale, for example, by the use of CCTV cameras. Let's now take a look at some further examples which are not specified in the GDPR, but which appear in the European Data Protection Board guidance on the topic. So any processing involving the use of a new technology, for example, a facial recognition system, or processing involving evaluation or scoring, including profiling, for example, predicting performance at work, an economic situation, health, or even personal preferences or interests, location, or movements should also be considered. This point would also include building behavioral or marketing profiles of end users based on website usage or navigation. Another example mentioned by the board is matching or combining datasets, for example, by merging data from two or more data processing operations performed for different purposes, or processing of data concerning vulnerable data subjects, for instance, data relating to minors or disabled persons. This could also include individuals where there is an imbalance of power in the relationship, such as in an employer-employee situation. In certain circumstances, cross-border data transfers, of course taking into account the countries in which the data will be received or accessed, should also be subject to a DPIA. And finally, processing that may prevent an individual from exercising a right or using a service or performing a contract should not be left aside. So, having these examples in mind will help you recognize the need to put in place a DPIA and comply with European data protection laws. But it's not just about compliance with EU laws. As Kirsten mentioned earlier, there are more reasons to conduct DPIAs, and there are a number of benefits. For example, a DPIA will help your organization identify effective ways to comply with data protection laws, not only in, but also outside of Europe. It will help to identify privacy risks and mitigate them. It will reduce risk of data protection law breaches globally and protect the reputation of your organization. It will increase transparency, accountability, and auditability. It will help earn customer trust by reinforcing the brand as a trusted organization, and it will save you money, as not doing one when required could imply more effort and higher expense. Now, let's move to the practicalities. How to create a DPIA. Here, we have summarized the DPIA process into 4 key steps, and we will go through each of them in the following slides. The following diagram covers each of the steps. First, describe the personal data, processing activity, and purpose of processing in question. Second, assess necessity and proportionality of the processing. Third, assess risk to data subjects' rights and freedoms. Fourth, document measures to mitigate risk and demonstrate compliance. We will now focus on the first step, which is to establish context. This would involve gathering information regarding the nature, scope, context, and the purposes for processing, a description of the personal data that will be in scope, the recipients of such data, for how long will data be retained, an operational description of the processing, a description of the assets used, which hardware, software, people, or even channels for transfer will be involved, compliance with codes of conduct, and any further information that is relevant in order to establish context, as we mentioned. And then, understanding whether there are alternative options and their viability. Could we do it in a different way? Let's now move on to the second step. Once we have identified the points we mentioned earlier and we have established context, it will be pivotal to assess the necessity and proportionality of the processing. In order to assess the compliance risk, we should be asking ourselves a series of questions. For example, is the processing legally permitted? Have we documented the lawful or legal grounds for processing under the GDPR? Is the data in scope adequate and relevant? In other words, proportional to the actual purposes? For how long will data be retained? Is it longer than necessary? Do we provide individuals with the opportunity to exercise their rights under the GDPR? How about our contract terms? Are the roles and responsibilities of the parties involved in the processing clearly identified? Moving on to the third step, it is now time to assess whether the processing will manifest in risk to the data subject's rights and freedoms. In order to assess so, you should consider what risks are there to data subjects. Is the processing depriving individuals from their rights? Could data be used in a malicious way? Could this cause distress or loss of privacy to individuals? And what would be the severity if this happens? Prosecution, financial loss, fines, investigations. What is the likelihood of such risk? The last and final step in the process of creating a DPIA is to treat the risk accordingly by documenting the measures chosen to mitigate those risks and demonstrate compliance. Some examples of risk mitigation could be anonymizing or pseudonymizing the personal data at stake, putting appropriate data sharing terms in place, consulting with your regulator about the processing activities that you're planning to conduct, implementing appropriate policies and procedures, and providing training to your staff, and so on. We have now established context, assessed proportionality and risk, and mitigated those risks by implementing accountability measures. The final steps to conclude the process would be to seek advice and recommendations from your data protection officer or DPO, if a DPO is in place. If to help with accountability you introduce a sign of process, make sure the DPIA is signed off by the appropriate people. And last but not least, remember that a DPIA is a living process to help you manage and review the risks of the processing and the measures you put in place on an ongoing basis. So keep the DPIA under review, and reassess if anything changes.
Thank you, Pilar. So now you should be better able to assess whether you need a DPIA, create your own DPIA process, and carry out your DPIA. Now, if you have any questions, please do get in touch with us. Our contact details are here, and we've also given you some information on where you can find useful resources. So please do visit our YouTube site where you'll find more useful webinars in our Get Data Protection Fit series. The ICO's website is always a good source of information. We have our own Fieldfisher privacy blog, so if you haven't subscribed to that yet, it's well worth doing. And we also have our own GDPR app, which is free and available in iOS and Android, so please do download it. Thank you everybody for listening.